Madam, Madam Presiding Officer, I thank you for the opportunity to contribute to the debate of this motion, which inter alia seeks to create a town and country authority and institution managed by the Tobago House of Assembly in keeping with the spirit of the Tobago House of Assembly Act 1996. And Madam Presiding Officer, for all that was said before, I know the majority side would have indicated the benefits. And as a proud Tobagonian, you know, I do not need to be convinced as to the importance of such a motion and, you know, the need for us in Tobago to have that authority to control the management of the town and country function here in Tobago. As a member of the People's National Movement and admitted by the Chief Secretary, steps were indeed taken before now to ensure that we have the institutional framework that can follow once the Planning and Facilitation and Development Act is fully proclaimed. As a matter of public record, Madam Presiding Officer, it is important to note, as mentioned, that similar matters of this nature relating to the effective management of the town and country function in Tobago have been pursued by previous administrations of this Assembly as a means to ensure greater efficiency in the processing of planning matters of Tobago. Madam Presiding Officer, I must admit that today's debate is indeed a bit bittersweet for me as a young Tobagonian. It is bittersweet because, you see, while we seek to salvage the dessert today, just a couple months ago, the People's Democratic Party, the PDP, caused Tobago to lose the entire three-course meal. The irony of today's debate is that had the PDP supported the Tobago Constitutional Amendment Bill as laid, then the town and country function that we now seek to claim would have automatically lay in the full premise of the Tobago House of Assembly. Because you see, we would have had control of those areas to which the Tobago Island government would have had unfettered control. In addition to the fact that the bill empowered not only the institutional framework for the town and country function, but the Tobago Constitutional Amendment Bill also provided us here in this very august house with the ability to legislate over those matters to which we want to control. Because you see, Madam Presiding Officer, one of the fundamental issues and challenges with implementing the town and country function is not so much the responsibility, but it has to do more so with the legislative authority. And because we in this house, all we can do is come and debate motions and cannot necessarily pass laws, then we do not have the legislative teeth to put into motion all the things that the very noble intentions, but we just do not have the legislative authority, or we just cannot just take the legislative authority from the Parliament of Trinidad and Tobago. That legislative authority needs fundamental adjustment to the relationship between Trinidad and the relationship between Trinidad and Tobago. And I would give you an example, because you see, what is playing here, Madam Presiding Officer, is not simply an issue of tongue and country in silos, but we all know that Tobago, there's a long-standing issue when it comes to land titles. And if you talk to the persons in tongue and country, they will tell you those same 300 files that the Chief Secretary cited as languishing somewhere, waiting for approvals. The majority of those files are really embedded with issues relating to land title and ownership. So until we have the legislative teeth to fix those issues right here in Tobago, we're really wasting time, you know? Because all the things that we want to have fixed by having the full control of the function cannot be fixed unless we treat with the attending legislations. We are talking about land title issues. Madam Presiding Officer, suffice it to be so, we on the minority side welcome the opportunity to salvage whatever is left, because we understand that there is still a great need to have the tongue and country arrangement that is more sensitive to the intricate needs of Tobagonians and our very delicate land title challenges. We support the move to address this, to fix this. And it's quite ironic and quite relevant that we have Mr. Charles in the chamber today, because I'm moved to quote one of his famous terms, which goes like this. Sir Charles always would say that good administration cannot fix bad policy. And therefore, it is my respectful view that while we hasten to implement this most noble and well-intentioned policy, we at the same time should seek to ensure that we dot our I's, cross our T's, we follow due process, and we ensure that at the end of the day, what is done right, and what we achieve is in fact good administration in harmony with good policy. Madam Presiding Officer, it is in this context that I posit to this honorable House that we all, notwithstanding our political differences, have a sacred responsibility and a solemn responsibility to ensure the policies we approve in the Assembly Legislature of the Tobago House of Assembly are in fact in harmony with the Constitution of the Republic of Trinidad and Tobago. It can be effectively implemented, and ultimately it can achieve its intended outcomes. And I know you are a new administration. I understand the excitement and the enthusiasm, you know, to get things done. As the Chief Secretary would have indicated. You all have your mandate. And we hear the cries. We all hear the cries of Tobagonians, and we want to treat with the cries of Tobagonians. But at the same time, we must appreciate that the THA Act in its current incarnation is somewhat imperfect, and in fact, it may be very well inadequate and irrelevant to the current needs of the modern Tobago. And it is for this reason I wish to caution this honorable House, because we talked a lot about Section 25(1) and what it says and what it means, and by now I'm sure most of the persons listening to this debate has a full appreciation for what for the letter of that specific section in the THA Act. But we must also consider that we have the sleeping, I would call the sleeping demon in the house. Because until we treat with 75-1 and the current cabinet domination when it comes to the affairs and the management of the Tobago House of Assembly, we will be in fact confined to a judgment that I would want to read for the attention of this House. And I'm surprised. You know, I'll give the Chief Secretary a pass. I know he was eager to score political points and come to tell us what the PNM didn't do. And I understand his duty. But I was surprised that the Secretary of, well, I'll call it Agriculture just for short because it's so long. But I'm surprised that the Secretary with his responsibility for agriculture failed to mention this very significant judgment that treats with the relationship of this very 25-1, the matters that we are responsible for in the 5th schedule, including forestry and the town and country planning. And this matter is in the name of the Tobago House of Assembly versus the Attorney General of Trinidad and Tobago, CV 2013-00153, dated 10th June 2015. And basically, the case summary is this, and I'll read it into the records very quickly because I have some other points I'd like to make. The Tobago House of Assembly is a statutory body created under the THA Act 1980. In its infancy, the THA did not have autonomy. However, a 1996 amendment to the THA Act was designed to remove the limitations which prevented the THA from implementing policies in relation to the Tobago, and particularly matters set out in the 5th schedule of the Act. The THA has alleged that the government has bypassed it and failed to collaborate with the THA on issues arising from matters failing within the 5th schedule of the THA Act. So here it is, we are dealing with a very similar matter. The basis of the THA's claim was that the government has failed to consult with and include the THA in much of the decision-making process as it relates to matters falling within the 5th schedule. This THA contends that it is in contravention of the provisions of Section 25(1). So this very section that we would have indicated that gives us all the power and all the responsibility and all the authority is under the spotlight in this judgment. A memorandum of understanding was drawn up in relation to this plan whereby the parties agreed to hold joint meetings to exchange and disseminate relevant information. Upon the expiration of the MOU, there has been no discussion or report forthcoming from the government with respect to the plan. As a result of the lack of information, the THA engaged its own project developers to prepare a project plan which was known as the Tobago Reforestation Program. Further to this, and under the National Reforestation and Watershed Program, there was the implementation of community groups. These groups acted as contractors, and persons from within the community were hired to work on the program. This thereby generated an income for persons in the community. The claimant, the THA, has alleged that sometime in August 2012, the government unlawfully terminated the engagement of these community groups in the National Reforestation and Watershed Program, contrary to the THA Act. The ministry later informed the workers that new contractors had been contracted, and there was a commitment in place for these workers with the new contractors. The claimant asserted that on proper construction of Section 25(1) of the Act, it is entitled to implement plans and policies in relation to all matters falling under the 5th schedule. Forestation is one such matter. Moreover, the claimant contended that it was necessary that it seek leave or approval from the cabinet or the government in so doing. Nor is the government entitled so to do without consulting the THA. And the court, upon examination of the THA Act, contended, and this is the court's ruling now, that the language of Section 25(1), the basis upon which our new institutional arrangement will be built upon, the language of Section 25(1) of the THA Act is plain and unambiguous. This court also noted that the fifth schedule responsibilities have a national impact. And what is instructive about this is that the court used as an example town and country planning. So the very thing that we are trying to deal with here today, the court in this judgment would have indicated.
Member for Darrell Springwim. Yes. Unfortunately, we would have to suspend the House until 5 o'clock. We are now going to take a tea break. We will resume at 5 with you. Okay. Assemblyman Augustine.
Madam Presiding Officer, I beg to move that we postpone the time for the tea break to allow the minority leader to complete his presentation, subsequent to which we take the tea break and then resume the rest of the sitting after the tea break.
Members, the motion is that the time be extended to allow the minority leader to conclude his presentation. All in favor, say aye. Any against? The ayes have it. Minority leader, please continue.
Thank you, Honorable House. So we were at the point where the court noted that the fifth schedule responsibilities have national impact, and of course the court cited some of the fifth schedule matters to which Tobago House of Assembly have responsibility for, such as town and country planning, the matter that we are discussing here today, infrastructure, including air and sea transport, wharves and airports and public utilities, telecommunication, as well as health services. And I'll touch on the health services a little later down to show you the difference in how you are able to actualize and harmonize policy and law. Therefore, the court contended if Tobago was allowed to have autonomy where these responsibilities are concerned, it would lead to confusion and potential disaster in the management and direction of national affairs, right? And I just want to summarize the order itself because it goes into more detail, right? Because it talks about the court found that on the plain reading of Section 21 of the THA Act, there are no powers given to the THA under the THA Act 1996 to the exclusion of the general powers given to cabinet. And as I remember, I mentioned this creature that is 75(1). And until we as Tobagonians can come together and treat with that very issue of 75(1) having domination over Trinidad and Tobago, my brothers and sisters, fellow colleagues, we really ain't saying nothing. The order is as follows. Thus, the order by the court in the matter of the construction of Section 25(1) of the Tobago House of Assembly Act, Chapter 2503, together with the fifth schedule thereto in relation to Section 75(1) of the Constitution of the Republic of Trinidad and Tobago, was that A, 1, Section 25(1) in its plain and ordinary meaning means that any responsibility given to the Tobago House of Assembly pursuant to Section 25(1) of the Act must be subject to the overriding and overarching national policy directives of the Cabinet of the Government of Trinidad and Tobago. B. Section 25(1) gives the THA responsibility to implement policies that are consistent with that of the government in the instances where the government already has policy in place. And of course, we only look at this current arrangement with Town and Country. There's a clear policy in place with respect to how we treat with Town and Country. And finally, C, which is very instructive, Section 25(1) of the Act does not give the THA, the Tobago House of Assembly, responsibility to formulate and or implement policy in respect of matters set out in the 5th schedule of the Act, which may frustrate or hamper the implementation of government policy. And with that, I rest this matter for the attention of the Chief Secretary and his cabinet in going forward in formulating your policy so that we can ensure that this most important issue is done properly. Madam Presiding Officer, fortunately for us in this chamber, and I just read the legal judgment and the issues there too. So therefore, the question we all got to ask ourselves is whether what we are doing here today is in keeping with this judgment and the law, and whether we are not in fact attempting to repeat the same thing, however, expecting a different result. Madam Presiding Officer, even if we contend that the courts were wrong, that the court judgment was wrong in its interpretation, and we as the THA do have the right to create our own statutory authority to fill the functions of Town and Country here in Tobago, how then do we treat with the current Town and Country Act, which in itself is very clear that all Town and Country function as it currently exists is subjected to the Town and Country Planning Act, Chapter 3501, Act 25 of 1960, and devolves the responsibility for the administration of Town and Country Planning to the Minister of Planning and Development. And the Act is clear, it states, the Minister shall secure consistency and continuity in the framing and execution of a comprehensive policy with respect to the use and development of all land in Trinidad and Tobago in accordance with a development plan prepared in accordance with the provisions of Part 2. And just before I go further, I just want to clarify a statement the Chief Secretary made, because he was on record as saying that wherever you see minister, it automatically is substituted by secretary, and that is not how the law works. In fact, if it's not spelled out in the law, then it doesn't apply. And in this instance, the minister means the minister. So yes, there's nothing, and it's clear, there's nothing stopping us from establishing the institutional structure. Nothing. However, we may end up no different from the very issues we're trying to solve when it comes to land title and Town and Country. A man with a piece of land with no legal title. And the very problems we are trying to solve remains because while Section 25(1) of the THA Act grants us sole responsibility, the Town and Country Act, as it currently exists, limits the THA's involvement and authority to implement the policy. Madam Presiding Officer, I am the consummate optimist. I am a Tobago patriot. I do believe there is a way we can satisfy both the spirit of this motion in harmony with the law. Thankfully, just as there is appropriate case study where the law and the policy was in conflict and there were issues, there's also a perfect template where the policy and the law were also harmonized. This example can be found in the establishment of the institutional structure for the implementation of the health function of the Tobago Regional Health Authority in accordance with the THA Act of 1996 and the Regional Health Authority Act. So, outside of us having the autonomy to come in here and have the law-making powers, if we really want to have the car...
Member, you have 5 minutes.
Does that include the 1 or 2 minute break that we had before the motion was moved to extend my time?
Yes, it was.
Okay. But I'm wrapping up, so... Thank you, Madam Presiding Officer. So, notwithstanding, we don't have the authority here to change what we are trying to do, then the next best alternative is to utilize this opportunity that we have with the Planning and Facilitation and Development Act, which is not yet fully proclaimed, and thus presents us with a perfect opportunity to ensure that the same way the Regional Health Authority Act was implemented, and in the same way it gave Tobago and the Tobago Regional Health Authority its autonomy, we can now use this template to ensure that we have harmony with policy and harmony with law. As I was winding up, and as I'm winding up, perhaps if I would not put it, but perhaps if we want to make this motion effective and get the kind of outcome that we seek, then perhaps we may further amend this resolution to also include and perhaps read a further amendment where we resolve to have this House authorize the Executive Council to take immediate legislative steps to harmonize the institutional structure with the applicable Town and Country Planning Law. I thank you.